Terry Fields, and welcome to Legally Speaking, produced by the Georgia Association of Black Women Attorneys. GABWA is a voluntary association, and this season we're focusing on attorney development and how to help attorneys in the next phase of their careers. Today's topic is mediation, and our guest today is the esteemed Judge Gail Tucson. Judge Tucson, welcome to Legally Speaking.
Thank you, Terry. I'm happy to be here. I hope you had a nice holiday.
I did. How about you?
It was great. It was great.
We're honored to have you here. And we just, like we said, want to talk to you about mediation. Could you just tell us a little bit about how you got into mediation?
Well, I have served on the Superior Court bench for several years and recently took senior status. But as part of trying to handle our caseload and get cases resolved, we've always encouraged people to consider mediation as a form of alternative dispute resolution, because that way you're more invested in the outcome and more likely to, follow the dictates of the agreement that you've reached with the other party. So I basically took my skill set from the bench and have launched an arbitration and mediation practice.
Now, for those who don't know, we're usually used to going to court and we fight. There's side A, side B, and we fight with each other. How is mediation different from that?
Mediation is nothing like what you see on TV. Everyone comes to court prepared to duke it out like you see on television. But mediation is an opportunity for you to, take a step back, kind of look at the big picture and be invested in reaching an agreement. So usually it'll be you and the other party. There might be attorneys involved, but that's not required. And then there will be a neutral, a mediator, someone who is skilled in listening and helping people to facilitate and reach a compromise.
Now, why, if you're going to court, let's just say you are upset, you're suing, someone has done you wrong, why would you advise that person to try mediation?
Because you know yourself what the best result is. And if you go to court, whether it's a bench trial, you have a judge making the decision for you. If you decide you want a jury trial, you have 12 citizens, strangers, making a decision for something that's going to impact you. And so in mediation, you're front stage and center, and you're able to talk through the issues and reach a decision that will work best for you. Plus, it saves you tons of money.
Right.
Litigation is very expensive.
Right. And sometimes it gives you an eye into what the other side is thinking, too, because you may think you have such a good case. And then
Exactly. So it gives you just an opportunity in a more informal setting to kind of go through your case. And, you may not reach an agreement, but you will learn so much more about the case prior to going to court if that is the ultimate way to resolve it.
Right. And right now, does anyone have to mediate? If they file a case in your court, is there any case where there has to be mediation before it can move
You
forward?
wouldn't have to mediate. It's a voluntary process. You don't have to reach an agreement. You may be ordered to go to mediation. Many judges, I certainly would be one, would feel that before you would want to invest the time and the expense in preparing a case for a multi-day trial, that you should try a mediation. So you will be strongly encouraged, but whether or not you reach an agreement is entirely up to you.
Now, how about divorce cases? Are they a little different?
They're different because the parties come emotionally charged, but they're ideal for mediation because, again, in this instance, you're able to focus on those issues that are most important to you and, try to get the other side to see your side of the story. You get to listen to their side of the story and reach a decision, especially if there are children involved, because what you want is an agreement that's going to be in the best interest of the children.
Yeah. Have you ever had a mediation where you went in thinking that it was not going to resolve at all, and it did? And could you tell us a little bit about it?
Well, that has happened. You sit down. The mediator is going to want to get to know the parties and their personalities, and you can pretty quickly pick up on the nuances of the personalities and maybe why there's a dispute based on the people that you're dealing with. But after you work with them, and this could be a day-long process, or it could take a few days. So it just depends on how complex the issue is. But sometimes, you walk into a room as a mediator and there's definitely an attitude and, pushback and, I'm not going to agree and all of this. But slowly you work through the process. And I think if both sides believes that the neutral is fair and has come to the process completely impartial, those are the cases where you may be surprised that you can end up with a result ultimately. I mean, you have a few tricks in the bag, which we're not going to disclose on Legally Speaking as the neutral.
Yeah.
But there are ways to kind of weave in the facts, the law, as well as the psychology of what's going on between the parties.
Okay. What if I were a litigant and I'm going into mediation? What can I expect? What's it like? Who's in the room?
Well, okay, so you can expect that when you arrive, each side will have an opportunity to give an introduction. And I like to hear from the parties themselves. So what I'm saying is that if you come with your attorney, we're not going to ignore the attorney. The attorney is going to serve a very important role. But initially, I like to hear, Terry, tell me, what is this case about? What's most important to you and why? And why are you here? And what are you trying to achieve? So that would be the first part. And I also tell the parties, to talk to me, not to talk to each other. Because when you talk to each other, then the emotion and the anger and the anxiety, all of that bubbles up and interferes with the communication, because the mediation is all about communicating. And so after you've heard from both sides, then I may try to do a brief review. And this is what I heard, Terry. Is this what you said? And is this what you would like us to focus on? And I'll do that for both sides. And then there will be a period of time where I will separate the two sides and we'll go into what's called a caucus. And I will talk more extensively with one side, and then I will have an opportunity to talk with the other side. So when you first start the mediation, as a mediator, I'll go over the rules so that you understand what's going to happen. I will stress that what you say is confidential, that I'm not going to run back to the judge and tell the judge, well, Terry said this. That would be counterproductive. So I try to establish a relationship where you trust me, and then I listen and find out what the issues are. I'm taking my notes. And then I can tell, based on my experience in this, what are the more difficult issues, the easier issues to resolve, and then we'll go through them. And ultimately, through the back and forth, so after I've caucused with you, and then I've caucused with the other side, and I may come back with you and follow up with a few things. You can tell me in each session what I can't share with the other. There may be things that you need me to know so that I can help resolve the case that aren't things that you want me to share, at least initially, with the other side.
And from beginning to end, how long is the whole process on average?
I'll say a day.
A day.
I mean, it just really depends on how many issues there are in the case.
Okay.
And sometimes at the end of the day, we may not quite have the agreement, but we're close.
Yeah.
And so you need to go home and kind of think about it, maybe talk to your attorney, talk to a financial advisor, other people that aren't in the room. Pray about it, whatever you need to do to feel comfortable. And then we may come back together for a second session. Or you may be able to kind of pick up where I've left you with your attorney or with the other side and kind of reach the agreement. But ideally, at the end of the day, there would be a written, at least, outline of what the agreement is, so that it can't change between when you leave and when we formalize it.
Absolutely. Okay, now I understand some advantages of mediation that you've already talked about is sometimes it's ordered, so it's kind of like checking a box, and then sometimes it resolves the case. But even with those, take both of those off the table, what are some advantages of mediation, would you say? And what are some of the advantages for someone who didn't resolve their case?
Well, they may resolve an issue, so they may not resolve the whole case, but let's just say it's a divorce.
Yeah.
So maybe they're able to resolve custody. So we don't know everything about the divorce. We don't know who's going to get the house and who's going to get the stocks and that sort of thing. But maybe custody is resolved, and that's a big relief. I mean, then you can kind of exhale. Okay, now we know, what the custodial arrangement is going to be, and now we can focus on, some of the nuts and bolts of the finances. So you get relief. knowing that you're making progress. I think we mentioned you may learn something about the other side or their case that is helpful to you. Those would be the primary reasons.
Yeah.
I think the benefits.
And
of
to be
mediating.
clear, you would never mediate a case that's before you, would you?
Oh, absolutely not.
Right.
So there would be concerns there because, again, remember I said I'm not going to take what you've told me and go back and tell the judge. So if the case isn't resolved and it needs a trial, then it needs to start from the beginning. And you don't want to be biased by what you have heard or an impression that you maybe have formed by one of the parties. If I come to the opinion that, you're really not as reasonable as I would want you to be, then if I'm trying the case, I don't want to start from the gate, well, okay, here comes unreasonable Terry, now we're going to have a trial. You want me to give you the benefit of the doubt.
Absolutely. Okay, and so I want to talk with you a little bit about how you became a mediator, or if someone wants to follow in your footsteps, how they could become a mediator. But first, let me just ask you, how is it different from a law practice, and what benefits have you found? I'm sure you enjoy it. I'm just assuming that. But what benefits does it have over a practice?
Over a law practice?
Why would someone add this to their practice? Why did you like it and you wanted to make it your practice?
So I was at the point where I wanted to do something different. So I had been on the bench for several years. So I came to this from the perspective of being a judge. So it's completely different from judging because as a judge, I make the decisions and you have to live with them. As a mediator, I have to take a step back and probably give you more control as the party over the outcome. And instead, I'm listening and finding areas for compromise that maybe aren't apparent to you. As an attorney, if you have a law practice and you're considering perhaps pursuing mediation, it gives you just another hat, another specialty. People can come to you. Other lawyers may be drawn to you by your reputation, by your sense of professionalism, and may come to you to help them with their case in another party. So it's a specialty. It's just an opportunity for you to use all the experience that you have developed as an attorney and share those skills with other parties that aren't your clients in terms of looking to you to take them to court and get an outcome.
Yeah. What cases are best for mediation?
So all cases, should consider mediation. I think cases that are ripe for resolution through mediation is where, the case has gone far enough where discovery has occurred. For our viewers, discovery is information that your attorney will get for you from the other side by asking questions, by taking depositions, by asking for documents. So cases where you kind of know what's out there, there aren't any undisclosed pots of information that you suspect are still out there, but you haven't yet resolved the case, those cases are perfect for mediation because you have the information, you know what your claim is. It's just an opportunity to probably get to a result sooner than waiting for the case perhaps to get on a trial calendar before a very busy court.
So, Judge Tucson, what is the cost of mediation?
So the cost, there is a cost. It's certainly less expensive than preparing for a full trial in court. It will depend. If you are using a mediator that is part of a court-annexed ADR program, then there will be a much reduced cost, probably a flat fee for a period of time that you would pay in advance to the court to defray the cost of the mediator. You may have an opportunity to pay the mediator directly if you're dealing with a private mediator, and usually then you'll be paying by hour. Both sides would be presumably paying the same amount. But that's something that you would want to be clear about to make sure that you're able to afford the service and that you can complete the mediation. You don't want to feel like one side is maybe paying for all of it and you're not paying for anything, because then there may be a concern about whether or not the mediator is truly impartial or if the mediator is, working on behalf of the party who's paid. So it's always good, even if it's a sliding scale, for both sides to pay something.
Do you have to be a lawyer to be a mediator?
No, you
Okay.
do not.
All right.
You do not. You need to get training, and so there are various entities that provide training here in our state and throughout the country. Many nonprofit or for-profit training agencies that give you the skills that you need to be able to do this. It's always good to be certified. So I'm a certified mediator by the, I think it's the Georgia Commission on Dispute Resolution. And it's similar to the obligations you would have as a lawyer. Once you get that certification, in order to maintain it and represent yourself to the public, as being a notch above and having the skills and the knowledge that are necessary, you have ongoing annual requirements, continuing mediation education, CMEs probably is what they're called, and you have to keep those up annually, and you pay a fee in order to be certified.
Okay. And if I were to add this to my practice, how do I get my first mediation cases?
Well, there are various ways. You can reach out to the director of various court mediation programs across your state. You could affiliate. There are mediation companies in our city and elsewhere. You could try to get on their panel, or you could do this on your own. Just like you would be setting up a law practice. You would have to market your skills. The best way to get your name out is to go to bar association events, specialty sections. If you're interested, for instance, in mediating employment cases, you probably should be a member of the employment and labor section of your bar association. It's good to speak on your specialty on panels. So you do your best to get invited to be a speaker. Because basically, it's not just, well, I'm a mediator, you like what I'm wearing. You want the person to have the skill set and the knowledge in the area so that they really are an expert and can help you resolve the case. And so you need to do, just like you would do as a lawyer, whatever is necessary to stay informed, to be on top of current trends, and to market your way in a way that people will want to come and use your services and know how to find you.
Yeah, so you would definitely recommend a specialty for your mediation.
Well, I guess my point is that if you're just a general mediator, you're competing against a whole lot of other mediators. Mm-hmm. If you develop an area in a specialty, expertise in a few specialties, then you will be able to stand out from the crowd. But no, you don't have to only do a certain type of case. Mm-hmm. You could be a generalist, mm-hmm. but there are a lot of people out there that are mediating.
Absolutely. And how would we get in touch with you? If I saw you and I said, I want Judge Toussaint to mediate my case, how can we get in touch with you?
Well, I'm affiliated with JAMS, which is a mediation and arbitration service that recruits retired judges. So you would just go to our website, which is jamsadr.org, I believe, and just scroll down, and you would be able to reach out and contact me directly.
Okay.
I'd love to help you.
Thank you so much, Judge Toussaint. We have learned so much about mediation. This wraps up this edition of Legally Speaking. We invite you to visit our website, gabwa.org, and our Facebook page for more information about our organization and upcoming events. We welcome your show ideas and comments on social media. For Legally Speaking, I'm Terry Fields. Again, thanks for watching.